Hi, this is Malcolm McCallum, and I'll be teaching wildlife management this semester. Today we will be doing a brief introduction, and we'll be looking at some of the history of wildlife management throughout the ages. Just to tell you a little bit about myself, that's me in the middle there with the yellow shirt. A few years ago, when we were at David Attenborough's Life in Cold Blood in Arkansas, this is my wife in pink and David Attenborough's in blue. I study herpetology, which is amphibians and reptiles, and I do conservation biology, ecotoxicology, behavior, and overall evolutionary biology and management of amphibians and reptiles. Okay, one thing we need to get straight right away is that there are two different spellings for wildlife. The first is a single word, which refers to wildlife that we see running around. The second is either hyphenated or it's a two-word phrase. That isn't what we're studying in this class. That's partying and general carrying on. I hope that you have signed up for this class intending to learn about wildlife and not the wildlife. Okay, so now we're going to talk about the history of the laws of wildlife management so we understand how the government got jurisdiction over wildlife and where everything sits right now. When we look at Western culture back to as early as the Roman Empire, we find that wild animals were looked at kind of like we look at the ocean and the air, in that they were part of the public trust and they didn't really belong to anyone or they belonged to everyone. However, unlike the ocean and the air, animals, wild animals that is, could become personal property if someone was to capture or kill them. The only real legal restriction back in Rome on the right to catch wildlife was that it had to be on the property of the landowner or the private landowner. And they could catch the wildlife that existed on their property and do with it as they pleased. When we reach the Dark Ages and we look at wildlife regulation at that time, the purpose behind it was completely different. Wildlife regulation actually was born out of the feudal system. And these feudal lords, they didn't want the people under them to come up and take over the feudal area. So they would regulate taking of wildlife in order to prevent people from having weapons. And so they didn't have weapons, they couldn't hunt, and if you were hunting, then you had weapons to do it, and if you could kill an animal, then you certainly could kill the king and take things over. So the purpose behind it might have been a little bit different, but this is really where we start to see regulation, and the idea that these animals can be regulated by the government. Wildlife and wildlife habitat regulation in England began fairly early, and for similar reasons to what we just spoke about. When the Saxon invasion came into England, somewhere around 450 AD, they started chopping up the land for the nobility. And any lands that hadn't been given to some noble person were retained as royal forests. And in these areas, only the king could hunt there. Of course, if that forest happened to be your responsibility, you were a private landowner, then you were expected that you were going to keep that wildlife habitat present so that the king could come over there and do his hunting. In 1066, the Normans came into England and they conquered it, and when they did, William the Conqueror and as many of the others, they started expanding these royal forests. And along with expanding the royal forests, they also brought in this idea of a forest jurisdiction. And what this was a whole bunch of, it was this elaborate system of royal forest laws. And these laws, together with special courts and officials who were charged with making sure the laws were upheld, were all brought in by the Normans. For example, one of the kinds of things that they had was that that there were these easements for the benefit of wildlife, and these were that allowed the forest officials to enter private land and remove vegetation needed for wildlife. Along with this, the king soon claimed the sole right to pursue game and take fish basically anywhere in the entire kingdom. And though he frequently allowed other people to come in and do it with him, one of the big things that happened was he started issuing these things called royal franchises. One famous one you may have heard of is the franchise of Park and Chase. And this allowed the person who got this franchise, they actually could pursue prized things such as deer, fox, and marten across their own land, and in the case of the former, across the lands of others. There were many of these franchises, such as the Free Fishery and the Free Warren, and they all did different things. As England's political system continued to evolve, so did this system of wildlife regulation. And by the 13th century, there were so many franchises for free fishery, and several fisheries had been granted, that there were these huge numbers of private weirs in the rivers, and it actually impeded navigation. So in 1215, when the Magna Carta was chartered, they actually had stuff in there about removal of the weirs. And later, the judiciary in England actually expanded this to bar the king from granting private fisheries in tidal waters. Over time, royal power of wildlife gradually gave way to Parliament, and Parliament became in charge of this. However, this didn't really change how the wildlife were dealt with. The principal mechanism of parliamentary control was enacted of so-called qualification statutes. So in order for you to take wildlife, you had to be qualified to take that wildlife. And to be qualified, what this meant is that you were wealthy, or land was prescribed in a statute, and so because you had money, you were qualified to take wildlife. So all this did was just perpetuate the problem that they were having, and class discrimination proliferated in England. And again, all this really is just to keep the weapons out of the hands of those who were considered unfriendly to the particular king. And that would be anyone who might not like being prevented from hunting. When the first colonists came into the New World, this is basically the way the wildlife were dealt with. You had the Parliament establishing these standards, and if you were wealthy, you were allowed to hunt, and if not, you weren't. So the forest jurisdictions were actually not a big deal anymore, but these qualification statutes still existed and were still very much alive, and continued well after, several decades after the American independence. In fact, on the eve of American Revolution, the King and Parliament had complete authority to determine what rights others might have with respect to taking wildlife. When the United States initially broke off from Great Britain, there were many laws that had been in place as part of British law that now had to be reevaluated under the Constitution, and many different agreements and so forth that carried over to the new constitutional law. However, some of them had, when they went through them, they had to be reevaluated because there were laws in Britain that would be in conflict with the Constitution and so forth. And laws that dealt with wildlife were no exception. In 1842, a case came before the U.S. Supreme Court in which Martin versus Waddell. And this case, basically what happened is that the landowner claimed that he owned all of the stuff that was in this area of land, including the oysters, and so someone couldn't come in and take those oysters. He claimed this based on a land grant that had been given to the Duke of York from King Charles II in 1664, and of course then he had obtained it from the Duke of York. The land grant certainly did cover the things he was suggesting. However, the question was whether this was still valid with our new Constitution. So, Chief Justice Roger Taney, who was the Chief Justice at the time, considered this case based on two issues. First, he looked at the character of the right claimed by the British Crown. In other words, was King Charles II, did he have the power to give this land grant? And then second, whether the character changed when the title of the lands passed from the king to the duke to the plaintiff. In the end, Taney declared that the Magna Carta had not given the king the right to give this land grant, in that the land grant couldn't include the oysters because they were part of the public trust. This decision is important because this made the states the successors to Parliament and the Crown. The ruling set the groundwork for the state owning the wildlife rather than a landowner. Prior to 1900, wildlife legislation in the United States was fairly benign, and its impact was pretty insignificant. But the few Supreme Court cases that did come by uniformly upheld the stance that the states owned the public trust. Several of these cases, such as Smith versus Maryland, McCready versus Virginia, Manchester versus the Commonwealth of Massachusetts, they all upheld different aspects of this. And finally, we came down to Greer versus Connecticut. Greer versus Connecticut is considered a landmark case because it defined the idea that the states owned the wildlife. And in this case, which took place back in 1896, what basically happened is that Greer was in Connecticut. He had killed these game birds, and he wanted to bring them out of the state. And in Connecticut, it was against the law to do this. And so the case was going to establish whether or not the federal government could regulate interstate commerce using game animals. In the end, Justice Edward White stated that the states have the right to control and regulate the common property in game as a trust for the benefit of the people. So this 1896 decision in the Supreme Court is what really set the foundation for the idea that the states can regulate wildlife. The first federal regulation for wildlife was the Lacey Act. And they based the passing of the Lacey Act on the idea that Congress has the power to regulate commerce among the states. The Lacey Act ultimately prohibited transport of wild animals or birds. Back then, birds and animals were not necessarily the same thing, that were killed in violation of state law. This allowed the federal government to aid the state in enforcing state laws. It also prohibited the importation of species that the Department of Agriculture had declared as harmful, things such as starlings and sparrows. And in response to the depleted passenger pigeon issue, which was clearly happening then, along with many other species, it also gave the power to the Secretary of Agriculture that the Secretary of Agriculture could adopt all measures necessary for the preservation, distribution, introduction, and restoration of game birds and other wild birds, subject to the laws of the states. So if they couldn't violate a state law, but so long as they were staying within state law, they could do anything they had to do in order to preserve these wild species. The Takings Clause in the Fifth Amendment of the U.S. Constitution is an important concept to understand regarding wildlife law. This states that private property may not be taken for public use without just compensation. It's important to realize that private property, this doesn't just mean taking away private property, but also reduction in the use of that property. Most of us are familiar with this, like they build a dam and they're going to flood up your farm field, and so you lose the farm field. And so the government, when they flood this, has to give you some form of payment for that farm field. However, in the case of wildlife legislation, usually the judiciary has not provided for compensation in most cases. Where someone has, for example, if someone has had a business that ran a hunting business, for example, and the state said, hey, there's going to be no hunting in this area, and so your business disappeared, generally they have not given compensation for that. Other things have been compensated for, and I've got a few of the key cases posted here. Well, that's it, other than for the bibliography. I got a lot of this information out of this book that's online on the Google Books if you want to look, but there's no need for you to do that. I'll try to have lectures like this up here every week or so, covering some of the topics that are in the class. I hope you have a nice day, and if you have any questions, just email me.